Started so that I know we're at the end of our day, but we have such a dynamic presenter up next. We are going to be hearing from Grant Dickinson, and he is, I'm sorry, let me start over there. He's been an attorney since 2010 and he earned his Juris Doctorate at Willamette. I probably slaughtered that. Okay. University. He's previously was at Provo 4th District as a clerk on their domestic violence team. He's also named Appellate Attorney of the Year in 2012 by the Parental Defense Alliance of Utah, and was recognized as a top attorney in 2020 to 2025. I cannot read today. In criminal defense and divorce law by Super Lawyers. He practices in family law, so he's doing divorce, custody, disputes, child support, petitions to modify orders to show cause, contempt, interstate child custody cases, and appeals. He also does child welfare cases, termination of parental rights, challenges to administrative findings by DCFS, state removal of children, reunifications, and appeals, and then also does criminal defense of DUI, drug possession, child abuse, theft, retail, theft, assault, witness tampering, and impaired driving. So really just has so much, a wealth of knowledge, and we are just so privileged to have him here and so grateful he was able to come down and present, and we'll let you take it away.
Get the microphone.
Yes, and he said he has a dance number for us, so.
That's right. Yeah. If I can get my music to work, it's actually really important to my presentation. I don't know, as far as like camera goes for the folks that are online, where this one?
Guy, so when you were up here.
That guy, will it track me?
Yes.
Oh, that's wicked awesome. All right. Well, thanks. We can talk about that. We can talk about stalking. Well, like I said, like she said, I'm Grant. I wasn't on the domestic violence team at the court. I was on the domestic team. If I played domestic, I could have said it. I don't know. I realized I cut and pasted a lot of that. The laws have changed. There's no orders to show cause anymore. They're all motions to enforce. Anyway, doesn't matter. I want to start and get you all up on your feet. Everyone stand up for me. And some of you will stand up longer than others. Even if you're online, stand up. I got to look at the owl there. So, all right. Now, those of you that have been victim advocates or worked in the victim system, I don't know if that's the right phraseology, but who have worked with victims of domestic violence for more than a year, keep standing. Those that have less, go ahead and sit down.
It's her second day. So.
Oh my goodness. Welcome. Welcome. But what about those that have been more than 2 years? Keep standing.
No, he's gonna make me go.
More than 5 years, keep standing. Wow, no one's sitting. All right, more. Let's go 10. Let's go big one. 10 years. That's a great crowd. Look, these are your mentors that are still standing. Who's done 15 years? More than 15 years. There we go. We lost a few more. More than 20. I'm gonna say 25. 25. 25 years, saying 25, 25. 30, 30, going 30, 31, 32. Thank you. Give them a round of applause. I know, let's see, which one do I click when I click on this?
The forward.
Oh yeah, you've done this before, huh? Yeah, right. I guess.
I might have just lost our mouse. It just likes to do that. Okay, it should work now.
So I used to be a victim advocate back in, this is 2021. Sorry, that's a lie. 2001. So in 2001, at Orem City, I was a victim advocate. So it is something that, I mean, that's where it started for me as far as like being involved in the law. That was my first job, like got me into the courtroom. Back then, we used the term gaslighting differently than the Dixie chicks use it, right? Like it's a little overused now, but it wasn't. But it was a great opportunity, got me into court, and I just really learned that I love the courtroom, and it got me in with individuals who were victims of domestic violence. I get to talk to them, got to talk to the prosecutors and communicate what they wanted to have happen, and what a great opportunity that is, and what an important opportunity that is for people who have had very, very limited voices and, in the relationships in their lives, get a voice through you. And I hope you know that while I'm the defense attorney and like the hated one here today, you guys can ask me any question you want. I'll tell you right what I feel. But I hope you know that what you do is really, really important, and I recognize that. And I still get to do that from time to time. The Utah County folks, I work with them all the time, and I do victim representation. And we see a lot of each other in Utah County. So, and sometimes I'm on the good guy's side, and sometimes bad guy's side. Sometimes you can't tell the difference between the good guys and the bad guys. It's just is what it is. So anyway, I wanted to let you know that I'm not totally oblivious to what victim advocate is. I don't know if I broke something already.
No, it's just that owl.
Hopefully can they still hear me online?
They can still hear you. They just can't see your
Oh, they're lucky. Sorry, y'all.
face right
You guys
now.
here in person have to deal with me. Okay, let's see if I got this right.
Yeah. Oh no, I messed you up. Sorry.
Oh, I don't know if it's quickly working.
It is. It's just me.
You're
That's
just watching for me to hit the button. You're like, oh, there you go.
Yeah.
So where I want to start is kind of this intersection of our three courts in Utah. Well, I say three courts. It's a little bit kind of a conglomeration, right? We've got our family court side. That's where we're doing our divorce and our all of our paternity cases, child custody and support cases. That's where they're at, right? We also do a fair amount of protective orders in there. And in criminal court, obviously that's where we're getting criminal charges. We do a fair amount of protective orders in there. And we heard a little bit ago from our CJCs about juvenile court, and there's a lot of protective orders in there. That is usually where my practice comes in. And like at my office, we have 9 attorneys. And anytime any one of these cases has a protective order, they call me. And so that's because of my background, right? I was at I worked with probation in the juvenile court. Oh, did I do that? I'm sorry if I messed that up.
No, it was me.
Okay.
I got you. 1 second.
You're
Sorry.
good.
Our owl just decided that he was done for the day.
Oh, you know what? I get it. Hope you're not done.
We're not.
Hang in there with me. If I talk too fast, I'm sorry. You can, any questions so far? Wow, we've talked about a lot right now. No. I give it a workout, right? I started moving left to right. How it's supposed to go all the way around, you know? Question in the back. Doll, give it to us.
So how do you say?
Oh, I do every aspect of its protective order. You bet. I have represented victims or petitioners in protective orders. I've represented children in protective orders, like in child protective orders. I've been a guardian ad litem several times. The county calls me and says, hey, we've got a conflict. Do you want to represent a couple of kids in a protective order case? And I said, sure. Right. The county, like, oh, well, Casey Warlick up in Salt Lake now. It used to be the county. Now it's the guardian ad litem's office. So I represent respondents, petitioners, and children in any of these aspects. So I've been on every side of protective order except for being the guy in the road. So I don't really want that goal. That's not for me. How we doing?
We're okay. Yeah, we're getting it.
So that's generally where I get involved in any of these cases, is starting with protective orders. And we'll go on to the next slide. So I want to talk a little bit about them in order. And there we go. So first in the juvenile court, and you guys may already know this. Sometimes the CJCs, and I love the CJCs too. If you haven't taken a tour of one, go take a tour. And that slide about what to do when someone reports abuse, follow that to the letter. All right, I'm a criminal defense attorney, right? When I watch interviews with kids, I'm watching for all the wrong ways that people ask questions, right? There is a modality to it. Follow it. If you are not trained in it, get somebody who is, right? Follow exactly what she said, and then get somebody who's trained to do that interview. I don't know if she had this at the beginning of her presentation, but one of the rights that we often talk about
There he is.
he's on. One of those rights that our kids in Utah County that we try to protect is to have the least number of interviews. And I'm going to talk about why that's important as we go through. But when we talk about juvenile court and child protective orders, that's where they generally start. Now, child protective orders can go to the district court under special circumstances if there's a pending other domestic case, a divorce case or a child custody case. If that's still pending, the juvenile court judge can send it to the district court. Okay, but generally the juvenile court judge will get these and they will review it.
Okay, and they're looking for really two things. They're looking for physical abuse or sexual abuse. All right, that's what has to be alleged in a child protective order. If you're alleging, well, dad called the daughter names, that's not enough for a child protective order. Okay, even if it's a push and shove, that's not enough. Has to be child abuse. Okay, easy rule for child abuse, right, is you're making a lasting mark. Right, which can be kind of hard if your children are very pale skinned and you squeeze their arm. Right, you can leave a lasting mark a whole lot easier than you can on somebody who's maybe darker complected. So that all goes into it, not to mention the fact that if it's a parent, they're going to talk about reasonable discipline and why in this moment that was reasonable. But what we're looking for again is child sex abuse, child abuse, right? Lasting marks. That's going to be your grounds for the entry of a child protective order. Will judges give child protective orders on grounds that aren't those? Sometimes. Can you get a permanent one on that? Yeah, sometimes. If you can kind of get the judge to go your way. Should they? Probably not. The statute's pretty clear, but there are some broadening languages, and the judges can sometimes be generous in trying to protect children. The great thing about it is you get a guardian ad litem appointed in these cases, and they're doing an independent investigation. And it's great when you have a guardian ad litem who gets down and talks to the kids, goes to the kids' homes, talks to both parents, and is really doing an independent investigation. That makes a big difference in not only short-term outcomes of what's going to happen with the child protective order, but that they can make a credible recommendation as to how this family needs to move forward, right? I say very flexible rules of evidence, and they are. Man, the rule of evidence in child protective orders is that anybody with information gets to talk at a child protective order hearing. That's the rule under the Utah rules of juvenile procedure. Anybody with information. There's hearsay, oh, we don't care, bring it in, right? Anything. Everything comes in a child protective order hearing. So these are great for getting the judge information. Another thing that you've got in juvenile court are all the resources that juvenile court has. It's not uncommon for once a child protective order is filed that DCFS will get involved. And DCFS has a lot of resources. They've got some counseling that they can do. They can put in safety plans. They can connect the parents with counseling and parenting programs. So those are some of the advantages that are in child protective order land or juvenile court. The one limitation is that they're generally limited to 150 days. They're short term. Okay, these aren't intended to be long term, but that may be a good thing, right? It may be that, hey, we just need to deal with this acute incident. Now, I say that knowing that there's a cycle of abuse and acute incidents, like, oh, of course, everything's gonna be great right after that acute incident, right? And we don't know how long that cycle is unless we've been in it. And so hopefully those that are involved in the juvenile court can be sensitive to that, and they're not forgetting that cycle of violence. And maybe that's where you come in. Maybe if you say, hey, you know what, this has been out of every 4 months, or maybe it's only been every year. So we need something that goes a little bit longer, or we need some treatment that will have some expectations that are a little bit longer than 150 days. And the courts have some flexibility on that, but it's somewhat limited. Okay, certainly if this is an outside, if it's Uncle so-and-so who's hit the child, then we can make that a permanent order. It doesn't have to be a 150-day order. 150-day orders is usually when we're talking about parents. So we've got one parent who's being a restricted parent, who's the subject of the protective order, and you've got the other parent who's requesting it. Those are generally going to be 150 days. If you're looking for a longer type case, you've got to come in and bring in DCFS so that you can do a child welfare case. Or we've got to be talking in the divorce court about how that we're going to have that long-term plan go forward. Now, obviously, at the divorce court, we're looking at 2 separate homes, and we're looking at a lot more complications. Child welfare side is great for when we're looking at bringing those homes back together. If we're looking for kind of maintaining a long-term relationship and educating all parties about the abuse and helping them get treatment for it. But if we know we're getting separated and we're getting divorced, maybe just throw it to the divorce court. But juvenile court's better equipped for certain aspects. Divorce court's better equipped for other aspects. So work with the teams that you have in determining which route is the best way to go. So that's it for child protective orders. Any questions on child protective orders? You can get one immediately, right? Well, not immediately, but you can go and file one today. The judge could, certainly I've gotten them done and filed them and had them signed by the end of the day. So if you file it right now, you could probably have them by the end of the day. Now, probably is a strong word. By the end of tomorrow, certainly. The judges generally look at those every day, in my experience, and they will have an answer for you within about 24, no more than 48 hours. And then they have to have a hearing within 21 business days. Okay, so it's kind of this short-term deprivation, which is kind of a big deal, right? Imagine if someone got a protective order against you and said, hey, I'm keeping your kid for 3 weeks. Or longer, I guess it can be up to 4 weeks, depending on how holidays land and the number of business days and how that particular judge interprets it. It can get a little bit messy. We got a question?
We have an online question for Christy. Do they expire when the child turns 18 if it is a permanent child protective order?
Right now, yes. At that point, the child can then go to the district court and get a longer term one, depending on the circumstances. But yes, right now, my understanding is that there aren't any that extend beyond 18, and that's because of the juvenile court jurisdiction ends mostly when the child turns 18. They can maintain jurisdiction in certain instances of child probation and following up with children in care, but generally ends when the child turns 18. I would ask that individual if I answered their question, but hopefully I'll give a thumbs up. Yeah.
Yes.
All right.
They said yes.
Do I just click on this one?
Yeah.
To make it move? Maybe.
Maybe. It's
All right.
very pretty.
I know that looks like a repeat slide. It is. But that's because I wanted to, okay, we're going back, we're zooming back out, and then we're gonna go to criminal court. Criminal court usually starts when someone's getting charged or arrested. Okay, in Utah, when there's an incident of domestic violence, the police are, it's almost a mandate, like 100% mandate that they have to arrest somebody. Because they don't, I mean, historically, why that exists, obviously, is because the police would show up and everyone goes, no, I don't want him, or I don't want her to go to jail. We're gonna be okay, leave us alone, don't charge us. And then there's another incident, right? And it's generally more acute, like you called the cops on me, right? I mean, as victim advocates, you've probably seen it. If not, you've heard war stories about it. Okay, that used to happen, all right? And it's probably been 20 years since they put that law into play. And it's been a good thing, for the most part. It's hard. It's really hard because we're arresting people and we're taking them to jail. But it has curtailed repeat calls to the police, repeat one night events. And hopefully maybe even save some lives. But when that person goes to jail, before they can leave, they sign a jail release agreement. Okay, which is an interesting thing. Like it's called an agreement, but if you don't sign it, you can't leave. So a little coercive, a little duress, like there's a contract issue there, but we're not talking about contracts. We're talking about the jail release agreement. You sign that I won't make contact with the victim, that I won't go to the victim's house, that I won't go to the victim's car, and I won't talk to the victim's kids. And 99% of the time, I won't talk to the victim who's my wife. I won't talk to the victim's kids who are my kids. I won't go to the victim's house, which is my house. I won't touch the victim's cars, which are my cars. Right? So it's a little bit complex, but we say, hey, you know what, work it out with the judge. Right? You want to leave jail? Great. This is your ticket out. If you don't want to leave, that's cool. You don't have to sign it. You can just hang back there until you see a judge. But they're usually replaced at that first hearing. Okay. The jail release agreements are good until that first hearing. Now, before they can be replaced with a protective order, the prosecutor actually has to file charges. If there are no charges filed, they can't turn it into a criminal protective order or a pretrial protective order. So if there's somebody that you're concerned about as a victim advocate, you see the police report come in, I make contact with the victim's like, yeah, I really need some protection. Or you as a victim advocate say, hey, prosecutor, you need to look at this and probably need to get charges filed so that we can get a pretrial protective order in place. You need to, be proactive on that, obviously, when that comes in and is part of your assignment. So that at that first hearing, the court does have the option to extend it. They can extend it 24 hours, right? But that just means they're coming back the next day. That buys the prosecution a little bit of time to finalize those charges. All right. And then it's converted into a pretrial protective order. And then ultimately they can even continue through the case and become a sentencing protective order. These are really great when incidents occur between two unrelated parties. Right? If they don't have to interact with each other ever again, it's great to have that protective order that gives you a little bit more peace of mind. I mean, I know at the end of the day, they're just orders and they're just a piece of paper, but it is a lot of peace of mind. And it's nice that, if that person comes around and and doesn't obey the order, you can call the cops and they'll be hauled away. Right, that's a little bit of relief, a little bit of high level insurance. Okay, so that's the process there. I want to go through a few of the pros and cons, right? Pros, that quickly obtainable, like, you're arrested, you don't get to leave unless there's a JRA. And generally before that JRA expires, you're looking at a pretrial protective order. That's a great thing about it, right? The next thing is it can last for a long time and can even go forever, right? Continuous protective orders are available, right? And the judges in domestic violence cases can and do routinely order these, right? They're free. That's the best part, right? You're not paying any attorneys, dirty attorneys. I tell you, they're the worst. If there's any online, any in here, don't raise your hand. No, they're free, they're great, and they've recently changed it. This is a new change, that they can actually order the defendant in certain instances to pay certain utility bills. Certain needs can be ordered to be paid by the defendant. It's really narrow, and that's good that it's narrow, right? And so you can work with that just a little bit, right? The cons are there are instant ramifications. This person is now being removed from the home. Calling the cops on a spouse is a big deal, right? For a lot of people, that's line in the sand type talk, right? And that's when we're talking divorce, it's a big deal, right? We're changing people's ability to work when they get arrested. I mean, if someone works in, maybe they're a police officer, they're working with something with national security, maybe they're an armed security guard, maybe they're anything that has to do with firearms. If you're arrested on domestic violence and you're signing a jail release agreement, goodbye to your firearms for a little bit, at least until the case is resolved. And so that's huge. Question?
Yes, could you speak a little more to the can order defendant to pay some bill? You're not talking about a JRA. you're talking-
No, not in the JRA. You're right.
Okay.
In an actual protective order part. What's that?
Sorry, can you repeat that?
Yeah, so the question was, in a JRA, can the defendant be ordered to pay bills? And no, the JRA is very, very simple, and usually it's three things. You're like staying away from the residence, staying away from their vehicle, and you're not contacting them. Okay, but it's usually very short. And the victim can actually come in and waive those. They can waive those terms. So the JRA gives a lot of flexibility to the victim if they know how to go through the proper channels. Changing a JRA, I make it sound easy, right? Who knows how to change a JRA? Like, ask it, okay, there's like one person in the room. I just did this last week, and you know how hard it was to find the right person for the victim to go to and sign off on it? Because there's one person at the police station that can accept the waiver, right? And they have to find that person in, and the victim has to be willing to go there. Yeah, so it's not as, I make it sound easy, it's not always easy. But yeah, so we talk about that, instant ramifications, and it's long-term ramifications, right? And that can be a big deal. If your victim wants to stay with the abuser, which never happens, right? Yeah, of course that happens, right? They've got longevity, they've got history with that individual, they love that individual, they've got children with that individual, their finances are intertwined. They've got a lot of reasons why they don't want that individual charged. A lot of reasons why they want that individual home, and they probably don't want to get in more trouble with that individual as well. Got a comment in the back?
So are you saying in a criminal protective order, you believe that the bills can be ordered to be paid?
In very narrow circumstances, utilities, it's like necessaries of life. If I didn't make that clear before, it's very narrow, right? Yeah, I mean, technically under the whatever else the judge wants provision that's in the protective orders, they could do more, but generally they're keeping it very narrow. Yeah, yeah, and we're gonna talk about the more robust ability to do that in the regular protective orders. Another question in the back?
Give us an example.
An example of what can be ordered to be paid?
Yeah, you said it's under a very narrow scope, and I
Yeah.
just haven't seen all.
Utilities. Utilities, and I think it's on the newest forms. So check with your judges if they have the newest forms of the criminal protective orders. If not, they can put it in the whatever else the judge wants. Right, they
Yeah,
can
there's a
include that in
line
there.
that says other orders.
Yes. So they can include it in there, and again, it's very narrow, and it's something that was just recently added.
The other thing I've seen is like that the defendant and the person that's against can come and get their property, they can
Yes.
specifically write that in.
Right,
as
they
well,
can, yeah, and then,
how to get their property.
yeah,
I just
Yeah.
haven't seen, but they're usually with bills, the separate.
Right.
Separation form that, but
Yeah, it's there in the law. There's one provision that says the court has very limited ability to order the defendant to pay certain expenses. And it's limited to expenses that they were already paying. We're talking telephone bills, power bills, mortgage, car payments, insurance. What they don't want is for them to enter a protective order and they say, fine, I'm not paying anything. Right? That puts us more in a financial, so this is to kind of just cover that gap. Like if we're basically taking the breadwinner out and not giving him motivation to, and I say him, right? I'm using stereotypical language. Hope no one's offended by it. Our one man in the room, sorry. And we all know that these stereotypes do bear out, and I apologize if anyone's offended by the use of him as the abuser and her as the victim. But as we go through like that, it just kind of, it bridges that gap just a little bit, where before there was no bridge, right? We're trying to get better at this as we go along. I mean, 25 years ago, I'm trying to think when we started protective orders. No, it's more than, no, I think about 25 years ago, they didn't exist except for as restraining orders. And then we made it part of the statute, create protective orders, and here we are. Right? We're still growing into it still. Anyway, yeah, so there's limited contact to deal with just the things that come up, like, oh, you know what, there used to be 2 people to get Johnny and Julie to their soccer practices. And now, you know, mom is having to do all of that, or dad having to do all of that, because mom or the other spouse or the other parent is excluded from the home. Or excluded from contact with the children, particularly when it's a domestic violence in the presence of a child. That's when they're gonna be excluded from the children. And those children hate that, right? Maybe not all the time, maybe sometimes they're relieved. But they still love their parent too, so it's hard to deal with all of those emotions, and these are blunt acts, right? This isn't surgery, this is no contact, or, you know, very limited contact. Yeah, they rarely deal with parent time. Most of the judges are saying no contact, and man, that I'm having that fight all the time with judges, where I've got a criminal protective order that limits my client's time with their child, or actually just says they can't have any time. And there's no mechanism right now in the law to get a hearing on the merits of whether or not they should. And obviously there's constitutional implications there, but that doesn't matter. That's what we're working on. We are talking about just, those are jail release agreements, criminal protective orders. They can go on throughout the entirety of the criminal case. And then obviously turn into sentencing or continuous protective orders at the end. You guys, this is probably the area you're all most familiar with, right? This is what you guys would deal with way more than I do. So occasionally I get involved in this part, but very rarely. So usually it's just kind of making adjustments to them so that they can be consistent with the district court orders. And that may be one recommendation I have on this is, as you work with these, if you know there's going to be later orders, when you put no contact, you can add in there no contact except for as permitted by the district court in either a civil protective order or in the divorce case. So that way you're not having to go back to the criminal court all the time and make adjustments. And then that allows the other courts to kind of do some refinement on it, or no contact with the children except for as approved by the judge in the domestic action. So you can put that in there right now so they're not having to constantly go back and forth. Any questions on criminal protective orders? Most of the time as a criminal defense attorney, I don't care about these because I know they're coming in. And the judges just routinely do them, and there's no, it's not on the merits. And it's so that, and if my client's gonna come in and enter a deal, like I know this is gonna come in and stay in as long as the judge and the victim and the prosecutor kind of want it to happen. So there's not a lot I can do to stop these. And they're not worth any effort on that, except for in changing the parts as to the children. That's where you can make some modifications to these and actually have a constitutional argument and have an impact on these as a defense attorney. All right. Let's see. Oh, yeah, that's a good point. Thank you for my slideshow, whoever put this together. One of the things that I think is really interesting about these is they can be ordered and remain in place over victim's objection. How many of you have had victim clients come in and say, I want it dismissed? And how many of you have had judges say, not gonna do it yet? And how many times has that, as your victim, 6 months later, then, holy cow, I'm so grateful I had that added time. And so, I mean, this is where you and your profession and your experience and your training get to talk to the victim and say, hey, Prosecutor's not gonna agree to dismiss it right now. Here's a couple of reasons why. And, you know, you can connect them to resources and hopefully they can see like the benefit of having some space when there's been an abusive incident or where there's been a long-term situation of abuse. Like we talked about before, violations are criminal charges and it's an instant arrest, it carries someone away, right? We like that part. Generally pretty easy to enforce, but again, it's a blunt axe. They don't have a lot of flexibility. Let's see, and yeah, this can be good or bad, and they don't deal with parent time. So those are just good or bad. These facts about criminal protective orders exist. And so just know when you're working on those, you can put in some flexibility or assist the prosecutor and the judge and your victim to input some flexibility so that you don't always have to go back to the criminal court. Because as it stands right now, of these orders, whichever is the most restrictive is the one that's in play, right? If the criminal protective order says no contact, even if I have one from the domestic court that says, hey, we can hold hands and make phone calls, it doesn't matter, because that criminal protective order is the one that matters. Whatever is most restrictive is the one that rules. Okay, now, as a criminal defense attorney, I'm always gonna argue ambiguity. Okay, but I'm gonna be telling my client, follow the most restrictive one. Why? Because that's good legal advice, right? And it's generally what the courts do, and that's what the courts will tell them. If there are if a judge becomes aware of multiple protective orders, they will generally instruct anybody who's involved in protective order. The most restrictive protective order is the one that governs your contact. Okay. All right, see that same slide again, because that's where we're going into family court, right? All right, generally these have the same protections as outlined in the criminal protective order, right? I can get all the same benefits. And it's still a court order and it's still a criminal ramifications, but I got a lot more, right? I can provide mechanisms for contact to facilitate parent time. I can say no contact except for at exchanges, right? I can say no contact except for through the Our Family Wizard app to arrange parent time. No contact except for through texting to arrange property distribution, right? So that gives us a little bit more flexibility, and we're already in front of that judge or commissioner anyway, frequently in the domestic case. So these aren't overly difficult to modify. And generally, when we're talking about these, both parties have an attorney. And so the attorneys can kind of talk, submit an agreed upon order, and then have the judge adopt that order to make appropriate changes. Unless you're in Salt Lake, then you have to have a hearing. Is anyone here from Salt Lake? You have to have a hearing on those protective orders, right? All right, it also can allow for contact and for mediation, which is great because then you can get the divorce and all the other stuff resolved. Cross your fingers. Provides parent time. What's not on here? Oh, there it is. It's the top one. It's on there. Child support and spousal support. Okay, not often argued. Now there's specific rules in the protective order that you have to do before you can get that granted, right? It's providing the financial information. Okay. And let's see, anybody here that actually works at the courthouse? No, all right, I'll just ask generally, how many of you guys have ever seen support awarded in a protective order?
Very rarely.
Very rarely, right? Yeah, like 1 in 1,000. Yeah, I mean, I've probably had 3 or 4 of those where the courts actually ordered that, because the court's like, hey, this isn't our normal modality. We want you to come in through a temporary orders hearing so we can look at all the financial information and make a call as best we can in a 20-minute hearing as opposed to a 5-minute hearing. All right, I know they've got more on this, but any questions so far on civil or domestic? Everyone knows where to find these, right? You all know where to find these. And it's the new paperwork, is that what they call it?
My paper case.
My paper case.
I think.
Used to be OCAT, that was so much easier to say and remember. But anyway, I've got that on the slide here. If you haven't walked through that process, if it's your second day, walk through that process. All right, you can't file anything through there. You're not gonna make a mistake and accidentally file anything, but walk through so that when you're going through it with a client or with a victim, you know what's there. Okay, man, I like the OCAP one better, just because that's what I was familiar with. It's so much easier to change too. Oh, and hopefully you all know how to like change text in PDFs, like pay the extra money for some kind of actual PDF editor, so that even when you're like, oh no, I don't want to go back into the system to answer the questions the second time, you can just go in and make changes through the PDF editor. That's the way to do it. But then you also gotta make sure your order is consistent with your request, so double check everything and have somebody else look at it too. Right, make sure it's the same on every spot. Yeah, some of the things that you wanna watch out for, we talked about conflicting orders, right? You think you're like, oh, I've got this order and it's great, you know, it allows for dad to have appropriate time with the kids, but there's also appropriate communication. But it obviously, if you've got a criminal court order that says something differently, that's gonna put a barrier on that. Just make sure you're not overlooking gaps. I mean, you're trained to see these, right? We're trained to look at this situation and go, all right, what does my victim need? Even though they may not know they need it. And be able to explain why. Hey, we're gonna do written communication. Right? I know we can put on there that they can have open phone calls. We're not gonna do that, right? Depending on the situation. What we wanna do is we wanna make sure that his communication and her communication are in writing. Because sometimes there's false allegations about what was said. Sometimes we don't remember what was said. When we don't remember what was said, it's always great to go back in the text log and be able to see what the exchange was. So be able to explain that to the victims as to why you're asking for that. And I mean, as a defense attorney, I love evidence, and so I mean, those text messages are great. And it's generally good for everyone. I use that as when I'm representing petitioners too. And people see dumb things in text. You don't have, and no one in this room does. But man, I can't believe some of the things that I've seen in text that we use later. I've had protective orders enter based solely on what's in text messages. So we love text messages. But make sure that you're covering their gaps that maybe they have blinders on for. And help them out with that, help them know like, hey, we've done this a little bit. This isn't our first rodeo, let me tell you why. Just watch out for non-safety related needs. Mostly I'm talking about finances. Right, if you can cover that in the protective order, or if you can get them access to a car, if you're, those types of things, and if you're looking at, hey, I need help getting the kids to all their practices, write that in there. Right, dad can come and get the kids for practices, mom can come to the house to pick up Jenny to take her to dance on Wednesdays. Write that in there. These are, you can write anything well, not anything you want, but generally, so long as it's agreed to, the judges will approve these. They want these parties to be safe, but workable. And don't overlook children's needs. Make sure that, you know, when we talk about getting the practices and things and getting parent time in there, that's gonna be important to the kids. Even though we may think this particular parent is a bad person for being an abuser, those kids still love that parent, even if it's supervision. We're getting supervised parent time in there and those types of things. We can get that in these situations. Also, I don't have it on here. We can get a guardian ad litem in certain instances in these. Right? If you ask for it and the judge approves it, get a guardian ad litem. Why? Because they're free. It's like having a free investigator come in and they come in with a lot of authority and credibility, right? They are non-biased, they're for the kids, they're doing their independent investigation, and they get access to DCFS records and investigations that no one else can get. Hey, anybody request DCFS records? Yeah, like how long do you, okay, no one raised their hand if you guys can't see online. The owl didn't pan the room. But nobody raised their hand. I request DCFS records on a daily basis. I'm waiting 6 months right now to get them back. But since they've gone to centralized return, I mean, it's a little bit frustrating and it's gonna create a due process issue. Again, constitutional stuff, we don't need to worry about right now. We got one more slide on these. There we go. There it is. That's my paper. That's the link. If you didn't have it, it'll be in the slides. I wanted to talk to you a little bit about when we fill these out with our clients. Talk to you about telling the story. Okay, and it's easy, right? Beginning, middle, and end. You wouldn't believe the number of protective orders I see that have, you know, nothing. It's like, well, he hit me, I need a protective order. And sure, most of the time, somebody hitting another person, that's gonna be assault, that's gonna be considered part of the domestic violence statute, right? But it's a way more effective if you can say, you know, on Thursday night, we were having a fight because I wanted to sign Johnny up for baseball, and Dad said, no, he wanted to be in a club team, not in the rec league. And he was really emphatic about it, and I didn't want to pay the club team costs, you know, and you tell the story, right? So that you want that when the judge reads this, you want the movie to click on in his brain, right? And he can see that, you know, the movie playing about what happened. They're having the argument about baseball, right? he got mad and picked up the baseball and threw it out the window and broke the window, right? Well, guess what? That's property damage, right? Used to be called criminal mischief, right? You do it in the house with somebody around to intimidate them, that's gonna be domestic violence. Right? I don't know if that's the right issue to go and get a protective order on, but sometimes it is. Right? And sometimes you need that moment in time to just create that, that protective order. But yeah, that's certainly an issue of domestic violence. But if they can play the tape in their heads of what you're writing down, right? And then you gotta tell us how it ends. What was the resolution that night? Did someone call the cops? Then I had to fix the window? Is that what happened? Or he made me fix the window, or then he said he was sorry and he fixed the window, right? Talk about the resolution, beginning, middle, end. Okay, that's important for the judge. It would be terrible for a judge not to understand exactly what had happened that night and not to understand that that was domestic violence. It was interesting as a court clerk, we would get fresh judges, and the judges come from all walks of the law, right? Some of them are civil judges who've never seen a protective order case. Some of them are criminal judges who have seen them in criminal protective order situations, but not in a domestic protective order situation. So our job sometimes, depending on who the signing judge was that week, is we'd have to put little stickies out to the side and say, hey, judge, doesn't this fall under this section of the domestic violence code? We'd highlight it for them. So we try to help out the judges, but you can do that too, right? You can put in there, hey, he threw the baseball out the window. Property damage statute is part of the domestic violence statute. You can go, domestic violence is defined as 76, whatever, right? I can't remember it off the top of my head. You can say, hey, part Z, because I think there's 26 subparts of the domestic violence statute, is property damage. I don't know if that's the real part. I don't know what letter it is. If I had my notes out, I can get it. But you can cite it for the judge, especially if it's something a little bit obscure, right? If it's something that the judges don't see all the time, like property damage is they're probably gonna recognize that as domestic violence. Certainly an assault, they're gonna recognize as domestic violence, right? But what if it's an interference with a piece of property? What if it's an interference with a phone? Right? That's interference with a property. Show the judge where that's at. Maybe he doesn't think that a spouse taking another person's phone is a big deal, right? Or taking the keys to the car, or blocking a hallway, right? Which, I mean, also in telling the story, say what happened in blocking the hallway. Right? Because if it's a spouse like, hey, wait, don't go yet. Let's talk about this. That's one thing as opposed to you're not going anywhere. Right? Make sure that you're telling the story so the judge knows it's that you're not going anywhere and not like, hey, hold on, can we talk about this for just a minute? Right? You've got to be able to tell that story as you're writing these protective orders and working with your clients. Make sure it's accurate. Oh, and don't forget the emotional details. How did it make you feel when he was standing over you, right? How did it make you feel when he threw the baseball out the window? Did it scare you? What was your response, right? Because that tells a story in and of itself. If I've got someone who's been through lots of trauma and has a what is elevated startle response, right? I'm getting there. I got to get all the right terminology. But if we've got an elevated and escalated startle response, and that tells the story. I jumped, right? He threw the baseball out the window. My immediate response was to jump up or back away or to cower, right? Tell that. I was really scared. He had done this before, right? Put that in there. Make sure that you're sharing that emotion. And what I don't have on here are do some observations with them. What did you see? What was the other person's tone of voice? What was in their stance that made you think that you were about to be abused? Right? Tell them what your client sees, hears, what is going on in the room. Put the judge in that room with your client. Because if you can do that, you're more likely to get that protective order signed, and you're more likely to keep that protective order at the hearing. Okay. All right. Now act like a human being. Okay. You don't need to do a ton of legalese. If you're citing to the statute, great. Man, every now and then you see one where it's like on Friday, December 15th, the respondent was following me. And it's like the respondent, the petitioner, and then he stood up as tall as possible, and it's kind of like, well, that is not how real people talk, right? I mean, there can be like, hey, he was following me and he came up behind me and he was, he looked huge. In my eyes, you can put in the physical descriptions, right? They're on the front page, but that doesn't tell the court the whole story, right? If he's 300 pounds and she's 120 pounds, that's a part of the story. Include that in there. It's intimidating to have somebody bigger than you around. I mean, I don't know. Just kidding. Cause I'm big. All right, sorry, that didn't. I apologize. That was bad. All right, yeah. Avoid these words. I'm sorry. I know that they are meaningful words, right? And I know that they have significance. Judges turn off when they hear it now. It's unfortunate. They've been overused in our society, and judges like, oh yeah, you know how many times a day judge hears gaslight or a narcissist? It's unfortunate because they do have meaning, but they've been so overused and that it turns off the minds of the judge. So be careful. It's better to describe what happened than it is to try to shortcut it. Right? Just say, he told me this, I later learned that wasn't true. We all know that's gaslighting, right? But it's better if you tell the story, let the judge come to that conclusion instead of jumping to that conclusion for the judge. Okay? Any questions on writing or requesting protective orders? Whew, I don't know what I just did. I'm the worst at this.
That's my case.
Oh, I clicked on the link. That's what I did. I didn't know that. All right. In addition to the on the request for protective order, I'm great. That'll be, can we cut that out of the video? Like, I don't know how to edit videos. All right. This is also key information. I tell you what, the judges, I think evidence makes or breaks protective orders. You wouldn't believe the number of cases where it's like, well, Your Honor, this is he said, she said. And you can't tell what is true. And if you can't tell what is true, that doesn't mean you don't know what to do. That means they haven't met their burden. Do you know how many times I've made that argument in court? Way too many, right? So guess what? This basically invalidates that argument. You can tell what's true. Here's a picture. Because then the other side has to explain away that picture, right? They have to explain away a recording. Because it exists. They can't, well, it doesn't, so he said, she said, well, except for this recording where we hear, clearly there's a struggle, clearly there's a hit, clearly there's someone crying out in pain, right? Explain that for me. That's what the judges will want. Pictures, medical reports, other witnesses' statements, text messages. We talked about that. We like text messages, right? Even emojis can be significant. There's a Utah Court of Appeals case that talks about the significance of an emoji. Right? Like, oh, you know what? I didn't mean to send her that emoji. And then she tells the story like, yeah, you know why he sent that emoji? This emoji actually comes from an incident that happened 4 years ago when he beat me up. And then it's like, oh yeah, I can see why that emoji has significance. Right? So if there's significance to it, tell that story. Here's the text. Here's why it's important. Right? You want to be like lawyers, put exhibit A, right? Exhibit B. You can cite that in there. That's not over the top. Give the court some, hallmarks of where to find these and attach them right to the request. Don't wait for the hearing on these. Attach them right to the request. That gives you so much credibility, right? I'm so confident that these things are true. I'm giving them on day one. Protective orders, man, it's a little bit old West style in protective orders, right? You can show up the day of and bring your stuff. That police reports on there? Oh, that's disappointing. Police reports, y'all, body cam footage. That's lousy. Man, this whole, man, all my credibility down the drain. Police reports should be on there. And I don't know if you guys know Mr. Kaplan, but he's amazing. He can teach you this stuff as well. So that's the civil protective order side. Any questions on telling the story, civil protective orders, evidence that you can provide? Okay. Here's what I do. Right, when I'm looking at these, and as from a criminal defense perspective, or from a respondent perspective, first thing I'm looking for is inconsistencies. Man, I love it when people tell two different stories. You wouldn't believe how much fun that is on cross-examination. That is the pinnacle of my professional career, is watching people tell a story on the stand that I know that they've told a different way, or that I know didn't happen that way, and just waiting to throw out that evidence, right? Isn't this what happened? Didn't you say this happened? And this is, I told you we come full circle in the CJC interviews. This is why we want limited number of interviews. Okay, because if I can get 4 or 5 stories, I can guarantee you there's going to be distinctions in the way the story is told that I can monopolize as a defense attorney. Okay, I'm looking for those. I read them over and over and over again. They live in my head, which is kind of sad because there's terrible stories that live there. But I will know if they change the way an incident occurred in court as compared to how they've written it down. Because I will read it and it just sticks in my head. I know how it happened. I've seen the video in my head. Right? So if they're changing the video, I'll immediately know that something's changed. Inconsistencies. The way that you avoid that, look at their affidavits, right? The sworn statements that they provided in any court. Look at the police reports. Make it consistent with the police reports. Okay, if there's an inconsistency, because it's possible, right? It's possible that you remember something differently, right? We've all done that. Explain that, right? Make sure you're telling the court, hey, this is why this is different. Especially if you can do that proactively, knowing that there's something that was stated incorrectly in a police report. Or that, you know, the term misremembered is a terrible term to use in court. You don't ever want to be on the stand and say, well, I misremembered that. Oh, I like that, right? Or I don't remember. Well, guess what? If somebody doesn't remember and somebody does, guess who has more credibility? Person who's telling what they remember, right? And especially because the other person isn't saying that didn't happen. They're saying, I don't remember. Well, if they don't remember, they don't remember. That's fine. My client does. This is what happened, right? Gotta go with the person who remembers as opposed to the person who doesn't. So watch for inconsistencies, especially with any of the other things that we talked about, any of the exhibits, right? They're saying, well, he hit me on the left arm, and then there's a medical report for a right arm sprain. I mean, that's gonna be a problem, an inconsistency, and if the attorney's doing their job and looking for those, they're gonna find them. So make it consistent, okay? Help them recall the details. If there's an inconsistency, explain it. Let's see. Oh, yeah, I mean, this is what I was gonna say. So I can't, as a criminal defense attorney, I generally don't communicate with victims, right? Because then that looks like witness tampering. But wow, it's an easy, witness tampering is a whole lot easier case to prove than assault. So I generally will keep away. Sometimes we hire a private agency to speak with them just to find out some additional information. Guess what? Your victim doesn't have to talk to them. Okay, so if my PI calls and says, hey, I just want to ask you a few questions about what happened that night, you can prepare your victim for that and say, hey, you don't have to talk to anybody about this. Okay, if you want to talk to somebody about it, talk to your therapist, right? But certainly don't talk to some PI that your ex-husband's hiring just to get a better, clear view of the case. I mean, they use the same techniques the cops do. I just want to understand. I know, I kind of know the outcome. I just want to understand what happened in between. They're trying to get a different story. That's their job. Okay, you can tell your victim not to talk to my PI. It won't hurt my feelings. Maybe a little, but guess what? Then I'll just have to deal with it. I'm tough. I can handle it. Okay, so if the victim isn't willing to cooperate with prosecution, and I can find that out, I'll use that. Right? I'm going to talk to the prosecutor and say, hey, from what I understand, your victim no longer wants this. And I can use that to either get a lesser charge, I can get a plea deal out of it. In rare cases, I can get it dismissed. But there are prosecutors who say, you know what, I don't care. I've got enough other evidence, I can go forward. So it just depends on the case, right? That's why the evidence is important. That's what I'm looking at from a criminal defense point is, what are the inconsistencies? What is the victim willing to do or say? What does the victim want as the outcome? I'm also looking at collateral consequences. Right now, the nursing board, I don't know if you all know this, but if I have a client who's charged with any kind of domestic violence charge, they will, in some instances, immediately lose their ability to work at hospitals. And that's a big deal, right? I don't know, you guys probably never had this. This probably never happens, where you've had someone who's in a victim circumstance their entire marriage. And then they feel empowered on one day and they slug the abuser. And what does the abuser do? He calls the cops, right? And he's got, or she's got, whatever it is, right? Got the marks on the face that day. And it's like all of a sudden everything's flip-flopped. And wow, that's a hard story to rewrite, right? But we can do it, right? If you've got all the right stuff in place, you've got years of evidence versus 5 minutes of evidence. The years of evidence can be helpful. So work with your victims on that. But there are collateral consequences of protective orders and criminal charges, right? We've kind of talked about these. It's that loss of income, that loss of access to income, right? They'll close off the bank accounts, they'll shut off the credit cards. Your clients need to be prepared for that. That time when that individual is in jail, maybe a prime time, get some money out of the account. Maybe a prime time to set up some of their own finances. Justin, close your ears. Before the domestic relations injunction goes into effect, there's no order of the court saying they can't take all the money in the account. right? There's probably some ethical rule about not taking all the money, you know, but half the money is traditional. Okay, at least make sure your client has enough to get from where they are to when they can get in a motion for temporary orders hearing, which can be a long time, y'all. When I first started doing this, it was 5 days between when you filed the petition for divorce and when you can get before a judge. And then it went to 14 days. I was like, oh my goodness. What's my client gonna do for 2 weeks? And then it went to 28 days. And it's like a month without any income. What is my client gonna do? What do you expect my client to do? Well, now it can be 90, right? I just set one earlier today, 90 days out. My client's like, what do I do? I said, well, you can go and talk to your religious leader, you're gonna talk to your friends, you're gonna talk to your neighbors, you can go get a credit card. You know, you get them some resources, right? There's food pantries. I mean, it's hard because these are folks that have probably never had to do that before, and are all of a sudden in kind of a poverty type situation where they've got to mind their pennies, and you've got to help them with that. So be familiar with those resources. But those are collateral consequences of criminal charges and protective orders. And then avoiding new charges, right? That's when we talk about conflicting orders, right? If in the domestic court, this happens all the time, y'all. Domestic court, you go, oh, everything's hunky-dory, I can go get my kids today. Goes over there, call the cops. He's violating the criminal protective order. Well, we just went to the judge, right? Like, yeah, so make sure that your orders are cooperating as much as you can. That's what, you know, part of the attorney's job when my client says, hey, am I good to go pick up my kids? I can't just say, oh yeah, we went to court today, we're good, right? It's gonna be, okay, hold on, let me check all of the protective orders. Because if you don't, you're gonna miss one. So you look up their name in the exchange system and you're checking all of those protective orders. Okay, so you gotta avoid new charges and you wanna avoid witness tampering, right? The children and the spouse are all witnesses. There might be other witnesses too. You're gonna have fun times with the kids. The kids will go, Daddy, why'd you get arrested? Mommy, why'd you get arrested? Well, because Daddy did this or Mommy did this. Yeah, that's witness tampering, you know, right? Because you're telling them a story, especially if they were there and they get, you know, if they haven't had their CJC interview, guess what? That's gonna be a tainted interview now because now they have more than what was there. So avoid new charges. These are my goals when I'm talking to my client. I gotta look for those inconsistencies to exploit those. Do we have a willing victim? If not, is there something we need to talk to the prosecution about? I'm looking at the collateral consequences for my client long-term, especially with licenses. Yeah, and caregiver, making sure that they can get in and see their kids. And then above all, avoiding any new charges, because then you get a new protective order, right? We don't want to do that. Then it makes it harder to get rid of the other one. Man, good times, y'all. This isn't complex at all. Anyway, at the end of the day, when I think about what we do when we're communicating with our new friends that have been in these incidents of domestic violence, and we help them kind of get a little bit of their life and their control back, right? When we can give them just a piece of peace, right? We're kind of those touchstones in their lives, giving them back what they should have had in the first place, right? What we hopefully in our own lives experience on a regular basis. You all familiar with the play Our Town? Our main character, Emily, dies. And the stage manager, you know, she meets the stage manager, who's another character, and he says, hey, we're not quite ready for you, so you can go back and visit one day that you had in your life. And all the people there saying, don't do it, Emily, don't go. And she's, I'm gonna go. She says, I want to go back to the day of my 16th birthday. So the stage changes and everything fades out, and her childhood kitchen shows up, and her mom's cooking at the stove. And Emily's there, Mama, it's me, Emily. I died, but I'm here. And her mom says, Emily, go get your brother. It's time for him to get ready. He's got to eat breakfast. Mama, I married George down the street, but then, you know, brother Johnny dies next year, and I died, and you died. Emily, go get your brother. He's got to come down and eat. He's got to get to school. And Emily turns to the stage manager and says, don't they get it? Don't they understand? And he says, saints and poets do a few, but the rest, no. You get the opportunity for your clients to again regain that ability to be saints and poets, to realize the wonders of life. And you get to do that yourselves. So go out and do that as you're helping your clients, help them be saints and poets and be that yourselves. Thank you. That's, let's see, how did I do on time?
Great.
All right, about an hour?
Yep.
Any other questions? I'm happy to answer any questions. Any online questions?
Not even come through yet.
All right. Well, thank you all. If you have any other questions, my contact information is on there. Feel free to shoot me an email, give me a call, and have a wonderful rest of your day. We're done early.
Thank you. Thank you so much, Grant. Ironically, my 14-year-old and 12-year-old are gonna be in the our town play at the junior high, so love that you saw that one. But thank you so much, Grant. We really appreciate it. I just think it's so important to understand kind of all, there's so many complexities and understanding that defense attorney is looking at what they have to do or looking at that on the civil end. So it was great that we could hear from prosecutors today and defense and kind of get that whole picture. So we just appreciate everyone being here. Please scan and fill the survey. We are not offended by feedback. If we actually want to, we want to make sure we're getting the topics on that survey. You can suggest another topic you'd like. And the handouts and everything is on that other QR code that you're welcome to do. And thank you everyone for being here today. And we have wrapped up our September swaddle. Our next one will be December 4th in Sandy, at the Sandy City Hall. So.
And we're
Thanks,
bringing
everyone.
a national speaker,
Yes, we're trying to bring in a national speaker for one in December, so, yep.
but also please feel free, I took off the rubber bands for the bookmarks, so it's a little bit easier for you to just grab a couple different designs, take these back to your office, and if there's any other material, please let me know, we'll get that to you as well. Thank you.
Thanks, everybody.